when the property values reduced, that meant that our tax base reduced, and therefore the city was harmed by the discriminatory actions that you undertook. And the banks say, I think somewhat predictably, and this is what the case is about, the Fair Housing Act is about discrimination. It's not about tax rates or anything like that. And your complaint here, it can't really be about discrimination, because if the banks engage in all sorts of risky lending on a totally race-neutral basis to everyone, you would have more foreclosures, more property tax declines, and less revenue for the city. So it's not about discrimination. You're just complaining about a business practice. And the banks are also saying this is a really long chain of causation. It's a kind of several-step theory. And what makes the case interesting is that 5 years ago, the Supreme Court in Title VII, in a case called Thompson versus North American Stainless, and dealt with this language about person aggrieved. And what the Supreme Court unanimously said there was that person aggrieved means, well, it's not only the victim of discrimination. It can be a step removed from that, like a spouse of discrimination or something like that suffers. But there have to be ironclad limits on that. It can't extend to the outer boundaries of Article III of the Constitution. The Supreme Court said that unanimously 5 years ago. The problem in that case was that they said, well, there were 3 cases that were decided 30 years ago that said for the Fair Housing Act in dicta that person aggrieved extended to the outer boundaries of Article III. The court in Thompson 5 years ago said that was dicta and ill-considered. The courts of appeals in these cases have said, yeah, the court has said that about the Fair Housing Act, that it was dicta and ill-considered, but they haven't overruled these earlier decisions. And so we as lower court judges are bound to apply them. And so the question in these cases is basically, can the court connect the dots and say, well, you've already said this about Title VII, now say it about the Fair Housing Act, or is the commitment to stare decisis, to precedent, so strong that it takes Congress to overrule an earlier dicta of the U.S. Supreme Court, even if it's 30 years old. So big cases of interest to the banking community. The last cases I'll talk about involve the IDEA. These are cases, the first one I'll argue on Halloween, and the second one in presumably January, was just granted yesterday. So the IDEA is the Individuals with Disabilities in Education Act, and it serves a really important purpose. Millions of children are now under the auspices of the act, and what it says is that it creates a process to ensure that students who have disabilities will have an education. And so the centerpiece of it is something called an IEP, an Individualized Educational Program, that is designed for a student working with the parents and working with the school administration to make sure that a disabled student has access to all the things they need. So, and it's a long iterative process, and the statute provides for due process hearing if the parents disagree or the student disagrees with the level of benefits they're getting. So the first case is a small one, I think, relatively, and that's a case called Fry versus Napoleon School District. And this is about Wonder the Golden Doodle. Now, I didn't even know Golden Doodles existed until like 5 years ago. Now it seems like the only dogs that exist in this country. But in any event, the Golden Doodle is not permitted after a long IEP process to go to the school. And then the parents sued, but they did sue under the IDEA. They sued under separate the Americans with Disabilities. The question in the case is, do the parents need to first go and sue under the IDEA before they can bring suit under these other provisions, an exhaustion case? The second case, Andrew F., which was granted yesterday, is a much bigger case. It's answering a question that the court's kind of left somewhat undecided over the last 30 years, which is how much educational benefit do you have to give a disabled student? Is there some minimum threshold or not? The court 30 years ago suggested there wasn't. There's a debate in the lower courts about how much of an educational process must there be. Very important also for constitutional scholars, because the IDEA is spending clause legislation, something that Greg knows very well, has litigated this. And so one of the big arguments in the case is, can states be subject to kind of open-ended funding restrictions or not?
Thank you, Neil. I have to say that learning that there is an association of associations here makes me think that we've got the setup for another Chris Buckley novel about DC. Um, Greg Katzis, our last panelist, is a litigation partner in the Washington office of Jones Day, where we are holding this event. He specializes in appellate and civil litigation. His Supreme Court cases have included NFIB versus Sebelius, the constitutional challenge to the Affordable Care Act. During the Bush administration, he served in many senior positions in the Department of Justice, including as Assistant Attorney General for the Civil Division and Acting Associate Attorney General. At the beginning of his career, he clerked for Justice Clarence Thomas, both at the Court of Appeals for the D.C. Circuit and at the Supreme Court. Greg, please.
Thanks, Ramesh. Welcome everyone to Jones Day. Thank you for coming. A lot of the major cases touch one way or another upon race. So let me begin there. Ted mentioned the redistricting cases. I'll mention two more. One is Pena Rodriguez versus Colorado, which is about racial bias in jury deliberations. There's a rule called the no impeachment rule. It's a rule of evidence which says that jurors cannot testify about jury deliberations in order to impeach a verdict. It's a venerable rule. It's codified in the federal rules of evidence and the rules of evidence of most states. This case is a Sixth Amendment challenge to that rule as applied to a case where the evidence that the defendant seeks to put in is very direct and very compelling evidence of racial discrimination in the deliberations. Facts of this case are about as bad as can be for the government. If you set out to make a hypothetical designed to test the limits of this rule, you would basically have the facts of this case. A Mexican defendant is convicted of some sex crimes. After the conviction, two members of the jury submit affidavits detailing how a third member of the jury pretty clearly acted on racial bias. The comments are quite striking. One of them is the third juror is said to have said, he's guilty because he's a Mexican. And to make matters even worse, the third juror is a former policeman who tells the other jurors that based on his experience in law enforcement, most Mexicans are guilty. The petitioner, the criminal defendant who loses below, has a pretty straightforward argument that the Sixth Amendment guarantees a right to a fair trial. It's obviously impaired when jurors act on very explicit bias like that. And whatever benefits may adhere in an exclusionary rule of evidence, that has to give way. That has to give way to the Sixth Amendment. The government is left to argue, sort of in the abstract, well, the rule of evidence is really important. There is precedent upholding the exclusion of evidence in cases involving other kinds of bias, and you can't really draw a principal distinction between bias based on race and bias based on, for instance, having a family member interested in the kind of dispute, which was the facts of the last case. It's going to be a pretty tough case for the government. I think it'll come down to whether the terrible facts of the case sort of overwhelm the general benefits of the evidence rule. I suspect the rubber will meet the road where the court gets into looking at the breadth of the exceptions and whether they make a special rule for racial discrimination or cases where the evidence is really direct. Next case I'll mention is Lee versus Tam. This was probably the most publicized case of the grants from yesterday. It's about registration of offensive trademarks by the federal government. So the Lanham Act says that the USPTO can't register a mark that disparages persons, institutions, beliefs, or national symbols. This case involved a music band called the Slants. It is a group of Asian American singers who want to use that term, they say, as an expression of racial pride, to sort of take back a stereotype that they say they want to embrace. PTO finds that the term slants is disparaging of Asians, refuses to register the mark, and the Federal Circuit holds that that prohibition violates the First Amendment. They characterize the provision as discriminatory based on content and viewpoint. They characterize it as keyed to the ideological and political component of the mark itself, rather than the role of the mark in facilitating commercial speech about the underlying brand. So they say this is political speech rather than commercial speech. And finally, they say this is more like government regulation than simply the government refusing to defining the content of its own subsidy program and simply refusing to confer a government benefit on speech that they don't want to subsidize. They say this is more than just the government talking about deciding how to spend its own money, as in cases like Russ versus Sullivan. This is the government refusing to extend legal rights to one group of private parties as against another group of private parties, and that's regulatory rather than a mere refusal to subsidize. The SG petition, not surprisingly, this was granted, as is almost always the case when the court strikes down a federal statute. This will have interest in the world at large, primarily because it's the same question presented in the Redskins trademark case. The Redskins were denied a trademark, the trademark was revoked. They challenged that, lost in a district court. Their case is pending on appeal in the Fourth Circuit. They try to get their case before the court on a motion for cert before judgment, which was denied. But however the court comes out in this case on the slants will almost surely determine whether the Redskins mark will continue to be protected. First Amendment, another interesting case called Trinity Lutheran Church versus Pooley. This is about the limits under the Free Exercise Clause on the government's ability to discriminate against churches and religious organizations in the provision of secular aid programs. So Missouri has a grant program which gives money to people who run playgrounds in order to buy a certain kind of environmentally friendly and safe surface, which is made out of recycled tires. The petitioner in this case is a church which runs a playground as part of its daycare center, and they are well qualified for the grant, but they are denied the grant because they are a church under a Missouri constitutional prohibition against giving any aid to churches. The challengers lose below, come up to the Supreme Court, and they say, number one, the Free Exercise Clause in the First Amendment prohibits discrimination against religious entities and religiously motivated conduct, and that principle governs the case. They then say that the federal Establishment Clause requires government neutrality and doesn't compel, doesn't permit, and certainly doesn't compel the government to affirmatively discriminate against religious organizations who want to apply for grants and such. The key precedent here is a case called Locke versus Davey. I think Ted was involved in that one as SG, in which the court made an exception to principles of neutrality and said that if a state government was conferring scholarships on a neutral basis to students who were worthy of scholarships, they could make an exception and discriminate against students who wanted to study for the priesthood because of the religious nature of that student's calling. And they said there's just something about using government money to fund education of religious leaders that allows the state to say, no, we don't want to do that. Even though the federal Establishment Clause would allow the state to do that. This is a case where I think the law could really make a difference. If you were looking at voting patterns in cases like this, going back the last 10 years, you might think this is the kind of case that's likely to split